Okay, let's just dive right in. We're tackling a topic today that it isn't just about tech or the market. It's really changing how we define something fundamental.
Something core to us, yeah.
I'm talking about AI copyrights. The whole explosion of generative AI is, it's shaking the very foundations of copyright law all over the world.
It's really not an overstatement to say it's a kind of identity crisis for, well, the entire creative economy. We've pulled together a bunch of crucial articles and legal analyses for you today.
And our mission, as always, is pretty simple. We want to use these sources to get you up to speed fast. We'll look at the legal precedents, the philosophical battles, and what's happening in the industry right now.
And as we went through all this material, one question just kept coming up,
What does it actually mean to be an author when the thing doing the creating might be a piece of software? How much human input is enough for the law to say, okay, that's yours?
And that question, it throws you straight into the deep end of the philosophical conflict. All the sources make it clear. The whole legal fight really hinges on this. Is typing a prompt into a box enough human activity to claim ownership? Or are we just kind of surrendering a piece of our human agency the second we click generate?
Let's spend a minute on that philosophical barrier, because it feels like it's the foundation for everything else. Historically, creation always required some kind of, physical action.
Right. The painter with a brush, a writer with a pen, the act of creation was tied directly to the physical subject, the body.
Exactly. But now you have these incredible results that are born, well, solely from an intellectual act.
That's it. You type a prompt, say, "Oh, lonely robot in a rainy, neon-lit city," and the AI gives you this stunningly complex image. So the question is, should that result, which came from just an idea, be treated the same as a painting made with actual brushstrokes?
That distinction, physical versus intellectual, it feels like a legal minefield. But the sources we looked at had a much more chilling warning about this idea of agency.
They do, and this is really the critical point. If we start to surrender not just the action of creating, but the justification for our actions to an AI, the risk is enormous.
Okay, wait, unpack that. What does surrendering justification even look like for an artist or a musician?
So it's more than just telling the AI what to do. It's when the creator can't really explain the why behind their choices. Why that chord progression? Why that color? Because the AI just picked the best one.
So the reason becomes the algorithm said this would be most effective instead of I wanted it to feel nostalgic.
Exactly. The human justification has been outsourced.
Yeah.
And the sources warn that if we do that, we risk living lives that are, well, subordinated to our own tech.
That's a heavy thought. The copyright battle isn't just about money then. It's about protecting our role as the subject, the driver of our own creative will.
Precisely. To avoid that future, we have to hold on to that agency. And that philosophical position is basically what the current legal system is desperately trying to uphold.
Which sets the stakes incredibly high. So, okay, let's zoom out. How is the actual legal system right now dealing with stakes this high?
Well, the international position is surprisingly firm for now. Most countries simply do not recognize an AI as a legal entity. An AI can't be an author.
So copyright is only granted if there's some kind of human intervention.
Yes, exactly. But everyone admits the existing laws written for, people are struggling to keep up with the reality of AI. Still, they're holding that line.
Yeah.
The author must be human.
And nothing made that clearer than the big one, the landmark case everyone needs to know. Thaler v. Perlmutter. This is where the philosophical question walked right into a courtroom.
It absolutely did. You have Stephen Thaler, he's an AI researcher, and he created a system called DBS.
Right, the device for the autonomous bootstrapping of unified sentience.
That's the one. And Thaler specifically tried to get a copyright for a piece of art that he claimed DBS made entirely on its own. The work was called A Recent Entrance to Paradise.
And his argument wasn't that he helped it. He argued the AI was the author, and he was just the owner of the AI. It was a really clean test of the law.
A perfect test case. And the U.S. Copyright Office just shut it down immediately. Their ruling was completely unambiguous. If a work is generated solely by AI, it's not eligible for protection, period. Law requires a human author.
But Thaler pushed back, right? He didn't just let it go.
No, he fought it all the way up. The final decision came down in March 2025 from the U.S. Court of Appeals for the D.C. Circuit. They ruled against him, and that set a huge national precedent.
And the language they used was so blunt. Something like, copyright law exists to protect human creations, and AI cannot be recognized as an author under copyright law.
That's pretty much it, a direct defense of the human's role in creation. This ruling is the current high watermark. It's the benchmark.
But, and this is the crucial part, there's a nuance here that makes it all messy.
A huge nuance. Because even with that strong ruling, AI-generated works have started to get some recognition. But it all depends on the level of human participation.
That's the gray area. That's the part that you, listening, really need to grasp. If it's not a total ban, where is that line?
It's a spectrum, really. The courts are basically saying, look, if you type in 3 words and get a finished novel, no, that's not protected.
Wow.
But if you use an AI tool and then you spend days editing, curating, adding your own distinct elements, making significant artistic judgments,
Then,
maybe.
so like heavy photo editing on an AI image or arranging and mixing AI-generated music stems.
Exactly. The human has to demonstrably transform the machine's output into their own unique creative statement. The tool is new, but the need for human creativity isn't.
Okay, so if the legal system is wrestling with this so much today, what about in 20 years? The sources had a fascinating prediction on that.
They did. They suggest that, yeah, big changes to copyright law are coming, but maybe not as fast as you'd think. The timeline they give is 20 to 30 years from now.
20 to 30 years. That's so specific. Why not 5 with how fast AI is moving?
Well, the thinking is that it's all about generational change. In 20 or 30 years, the teenagers who are growing up with this stuff right now, for them, AI isn't disruptive. It's just a tool. They'll be the judges and lawmakers.
So we're waiting for a cultural shift to force the legal one.
That's the idea. The expectation is that the kinds of creations being rejected now, like Thaler's, will probably be fully recognized within that time frame. You just can't fight that kind of cultural momentum forever.
So while we wait for that, the industry isn't just sitting around. This brings us to the music industry, which the source is called the good news ?
Yeah. It's a huge shift in strategy. Just last June, you had the big record labels, the RIAA, filing these massive lawsuits against AI music generators like Suno and Udio.
Right, and they were asking for insane amounts of money, something like $150,000 per song. They were trying to sue them out of existence before they could even get big.
It was a scorched earth approach. But here's the pivot. The RIAA is now showing real signs of shifting from litigation to, well, negotiation.
Why the change of heart?
I think it's just pragmatism. It's a recognition that the AI era is here. You can't sue this technology away, and the scale of it is just too massive to fight in court forever.
So if they do reach a settlement, what does that actually mean?
It would be historic.
Yeah.
Genuinely. It would establish the first real copyright standards for AI music, and it would probably set the template for the whole world. This is where the future of music licensing is being written right now in those rooms.
And what's on the table? What are they actually talking about?
The reports mention things you'd expect, like, licensing fees for using music and training data, and new tracking systems, because the old ones can't keep up.
But the really interesting part was the talk about equity.
That's the big tell, isn't it?
Yeah.
It means the labels don't just want fees. They want a piece of the AI companies themselves, an ownership stake.
Wow. So it's a full-on, if you can't beat them, join them strategy and own a piece of their success.
Exactly. It's an admission that this is the future, and they need to be part of it, not just fighting it.
Okay, so we've got philosophy, legal precedent, industry negotiation. Let's bring it down to the ground level. What happens when all this AI content floods the platforms we use every day?
Well, the sources point directly at YouTube as the platform feeling the biggest impact right now. The problem is simple, really. A massive flood of AI content has just led to user fatigue.
People are getting tired of it. You see enough of the same style of low-effort video, and you just tune out.
Right. And that has forced YouTube to create some really strict new policies. For creators, this is what you need to know.
What are they?
First, they've put major limits on monetizing content that's made entirely by AI. You can't just press a button and collect ad money. But the biggest rule is mandatory disclosure. If your content uses AI, especially for realistic-looking stuff, you have to label it clearly.
And if you don't? If you try to pass it off as real?
The penalties are serious. Your content could be deleted. It could be flagged as misleading. And if you keep doing it, they could just remove your entire channel. They're trying to force transparency.
So when you connect all these dots for you, the listener, it becomes really clear. The platform rules at YouTube, they reflect the legal pushback from the Failure case,
Mm-hmm.
and they both show why the industry negotiations, like with the RIAA, are so necessary. It all comes down to transparency and proving some level of human input.
The entire system, from the courts to the companies, is trying to put human responsibility back onto these tools that are designed to minimize human effort. The question is shifting from, can AI make this, to, okay, but what did you actually do?
So to wrap this all up, the issue of AI copyright isn't just some simple legal problem you can fix by tweaking a law. It's a really profound philosophical question about what creativity even is.
And as the technology just keeps getting better and better, these conversations are only going to get deeper and more complicated. We're at a point where we need not just new laws, but a real social consensus about what we value in the act of creation itself.
A consensus that could be decades away, driven by the next generation. But for now, we're in this messy middle ground where the law says copyright depends on the level of human participation. So we want to leave you with a final thought to chew on.
Given that the law is drawing this blurry line based on participation, where do you draw it? On that spectrum, from just typing a simple prompt to spending weeks editing and curating and refining, where does true authorship begin?
What percentage of the final work needs to be distinctly human to deserve protection? Something to think about until our next deep dive.